Thank you for attending our talk on reasonable adjustments in the Employment Tribunal. Here are some of our top takeaways. First, we discussed the presidential guidance on vulnerable witnesses and parties in the Employment Tribunal and the Equal Treatment Bench Book. Both list a process for how to have reasonable adjustments assigned in the Employment Tribunal, including a ground rules hearing, which is basically a preliminary hearing focused exclusively on reasonable adjustments. Both also give suggestions of types of adjustments, and the bench book separates them out by impairment and can be very helpful. The second issue we discussed is the case law behind this area, particularly focused on Rackham and NHS Professionals Limited, and Habib and Dave Whalen Sports. Both encourage and say an employment tribunal should look to the bench book, consider the overriding objective, and ensure that the party can effectively participate in the litigation. The third issue we discussed is the process of requesting reasonable adjustments. You put together a list with the chosen adjustments that you would like to request. Then, in our recommendation, you provide medical evidence in support. This could be a letter from a GP, or if you have targeted specialist medical support. We would recommend you give this list in your application to the other side and see what you can come to an agreement on. If not, there might be cause for a ground rules hearing, again, to focus on the tribunal making the decision about those adjustments. We also recommend that this happen as early as possible, because some of the adjustments may have to do with the entirety of the litigation and not just the hearing. Next, we move to briefly discuss requests for an intermediary. Again, an application must be made and the tribunal will decide whether this is in the best interest of all the parties. An intermediary can be extremely helpful in ensuring that the party has effective participation in the litigation, but it's also helpful for both parties and will be appointed by the tribunal. Finally, we discussed actual adjustments to be requested. These can be as basic as just more time or more breaks, but also to think more deeply, such as screening between parties or adjustments to cross-examination, which could be getting the topics ahead of time, getting the questions ahead of time, or even doing cross-examination ahead of a hearing outside of the courtroom, possibly with a judge asking the questions. Again, there are very helpful lists in the presidential guidance and the bench book. And the tribunal will balance making sure that those adjustments are targeted to the individual, as well as balance them against the other party's fair trial rights.